don't say that on camera. Alright, here you go.
Can I hit my neck?
You don't.
You
don't say that on camera, bro. You gotta hit the court. It's gotta be fucked up. So you don't say that on camera.
Alright.
On April 23rd, 2023, a Florida officer arrested a young driver who fled a traffic stop. After Miranda, after the confession, the officer protected the subject from himself. This analysis examines Miranda compliance, voluntariness of the admission, and whether defense protective coaching completes the officer excellence triad.
Over here. Hold you. Alright, hands behind your back.
Can I take my phone?
What?
Can I take my phone?
Yep. Alright.
Can I get my phone real quick?
Hold on. I will get it for you, okay? I'm going to go back to my car. Nothing on you, right? In your pockets?
No.
Okay. Have a seat.
I don't think.
You're under arrest. Have a seat.
Have a search.
Yeah, you can see it right up
Is that 446?
there. While you are being questioned, you cannot afford one, to hire one. Will be appointed to you to represent you before any questioning. If you wish, you can decide at any time to exercise these rights, not answer any questions, or make any statements. You understand these rights as I've read to you?
Mm-hmm.
You have these rights in mind, you wish to talk to me. But you saw me pull out, and then what happened?
I honestly just thought I could get away, which was kind of stupid in hindsight, because I don't want to pay a ticket, but now I'm arrested, so...
Yeah, now you're going to jail, correct. Search you, then we're going to put it in the back of your car, okay? We'll do some paperwork.
Yeah. You have anything on you that's going to hurt me, stick me, poke me? No. Good. Anything in your shoes? No, should I take them off? No, you're fine. Alright. Come on.
Under United States v. Watson, 1976, warrantless public arrest on probable cause is permissible. The fleeing conduct supplies probable cause under Florida Statute 316.1935. The eluding statute tiered from misdemeanor to felony. Miranda warnings administered before substantive questioning. Satisfy the Miranda v. Arizona, 1966. Constitutional minimum. The voluntary admission immediately after Miranda is analytically significant. Under Schneckloth v. Bustamante, 1973. The totality of circumstances voluntariness framework governs. The articulate self-reflection, quote, kind of stupid, in hindsight demonstrates awareness incompatible with coercion-induced compliance. The waiver was knowing and voluntary.
Well, walk over the bench on the other side of my car, okay?
Never went home? Yeah? No?
Okay, thank you. What's your mom's phone number, Natalie?
She got it on her phone.
My last phone number?
No,
my phone number?
yeah.
727-554.
Your phone number? No,
No.
you need a house phone number.
Oh,
Somebody got your contact phone.
596.
72. Yeah, appreciate it. Thank you.
596. 8104.
Who is that?
That's the house phone. It's
Okay.
gonna ring the whole house. Either Mimi, Papa.
Do they know what's going on?
Answer it.
They know what's going on?
Do you think they know what's going on?
Why did you tell him you gotta run him? You don't say that on no camera. Alright, here you
Can I
go.
hit my neck?
You don't.
No,
You
no.
can't- You don't say that on camera, bro. You gotta hit the court. It's gotta be fucked up.
So,
You don't say that on camera.
all right, so you got that. All right,
He lit the infinity up.
so,
Alright,
all righty.
I appreciate it.
Yep.
If the subject is a juvenile, JDB versus North Carolina, 2011, activates age-aware Miranda analysis. A reasonable juvenile may experience custody differently than a reasonable adult. Under Gault, 1967, the foundational juvenile due process case, juveniles are entitled to constitutional protections, including notice, counsel, and self-incrimination. Florida Statute 985.1.01 requires parental notification. This is the editorial centerpiece. After Miranda was discharged, after the confession was on record, the officer affirmatively coached the subject not to make further self-incriminating statements. This conduct exceeds the constitutional minimum. The framework is Defense Protective Coaching Doctrine, non-constitutional but professionally exemplary, derived from common law police authority and community-oriented policing ethics. The doctrine completes the officer excellence triad. The arresting officer earns an A, potentially A+, procedurally correct Miranda timing, professional search incident to arrest, exemplary juvenile justice protocol, and flagship defense protective coaching. The subject earns a C. Cooperative voluntary admission and articulate self-reflection partially mitigate the dispositive willful fleeing conduct. 3 lessons emerge. First, fleeing is always a net loss. Florida penalty escalation from misdemeanor to felony makes the math sharp. Second, silence is the default setting. The right to remain silent exists for structural reasons, protecting both legal and emotional consequences. Third, officer excellence has 3 pillars: compliance through legitimacy, preventive policing, and defense protective coaching, describing officers operating beyond the constitutional minimum before, during, and after arrest. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Street Bodycam, for even more police interaction and courtroom content.